Okay, let's talk about ratification of the Constitution. Initially, the individuals that were opposed to ratification of the Constitution were known as the Anti-Federalists. Some of the primary reasons why they were opposed to the ratification of the Constitution would be the fact that this social class, and we'll get to that in just a second, was able to secure control of most state legislatures. So they feared a shift of power away from state legislatures that they did control, or at least had some influence in, into this new national government that they would have little influence over. In fact, if you recall, the Constitution does provide for only limited popular participation, and their fear was that level of participation wouldn't be enough, and that their social class and their interests would not necessarily be represented. So if we look at the social class differences or the distinctions between the Federalists and Anti-Federalists, we see kind of a dichotomy emerge. In terms of social class, the Anti-Federalists tended to be from lower class up through middle class, and occupationally they tended to be farmers or those involved in agriculture, agribusiness, what we would call agribusiness today. The Federalists, on the other hand, tended to be more merchant-oriented. They tend to be from middle class up to more wealthy individuals. A series of essays is going to be published in a New York newspaper entitled The Federalist, sometimes called the Federalist Papers. They're written by Hamilton, Madison, and Jay, and what those articles are going to do is they're going to outline the Constitution, how it's supposed to work, or at least according to Madison, Hamilton, Jay, how it was supposed to work, and try to serve as a point of advocacy for the adoption of the Constitution. The significance of the Federalist is that it tends to be about the best commentary that we have on what at least three of the framers thought the Constitution should be and how it should work. Ratification of the Constitution will occur whenever 9 out of the 13 states ratify it. This will take place in 1788. So the Constitution will become operational with 9 out of 13 states approving it. All 13 states will eventually approve the Constitution by 1789. The Constitution of the United States limits governmental power. It does so several ways. Number one is going to be federalism. Federalism is a division of power between a national government and regional governments, which we in the United States call states. In the United States, the national government has delegated power, which means they can only do those things that they have permission to do. We'll speak more about that in just a second. Whereas states have what's called reserved power, which essentially allows them to do anything they want unless there's a specific rule against it. So between the two, the fact that the government is divided makes it more difficult to do things. Another way that power is limited at the national level is separation of powers. Separation of powers means that lawmaking, law executing, and law interpreting functions are going to be put into separate institutions. Checks and balances also limits the power of the national government. Checks and balances is where one institution of government has the ability to check or to counteract an action of another institution. For example, the Congress may pass a law, but the president can veto the law, and the Congress then could attempt to override the veto with a two-thirds majority. The Constitution also provides for judicial review. The Constitution does not explicitly state judicial review. Nowhere in the Constitution will you find the words judicial review, declare something unconstitutional. However, it is absolutely sure that it flows logically from the text of the Constitution. The Constitution of the United States provides that it is the supreme law of the land and that all judges shall be bound to it. The first time that the U.S. Supreme Court dealt with the issue of judicial review is in the case of Marbury versus Madison. And again, the Constitution does not explicitly provide for judicial review, but the court asserts its right of judicial review in the case of Marbury versus Madison, and that is why it is significant. There's two other cases that are of minor significance that won't necessarily be relevant for this course. However, they are worth mentioning briefly. Fletcher versus Peck is the first time the U.S. Supreme Court asserted its right to review state court decisions to determine whether those decisions are in agreement with the U.S. Constitution. And Martin versus Hunter's lessee is the first time that the U.S. Supreme Court asserted its right to review a state law to determine whether that law was in agreement with the U.S. Constitution. As previously mentioned, power in the United States is divided up among different levels, the national level and the state level. At the national level, the national government is said to have delegated power, which means powers that are given to it by the people. Okay? Delegated power can be further subdivided into two other types, expressed and implied. And again, delegated power means the national government can do only those things that it has permission to do. So in the express powers, we find a specific mention, a specific list of those things that they are allowed to do. These express powers are also known as enumerated. Implied powers are a function of the elastic clause, also known as the necessary and proper clause. The implied powers allow the national government to do not only the things that are expressed, but those things that are related to the express powers. The elastic clause is first interpreted in a court case called McCulloch versus Maryland. In the case of McCulloch versus Maryland, the U.S. Supreme Court opted for a rather broad or a loose interpretation of the elastic clause, and this has had the impact of growing national power. Also in McCulloch versus Maryland, the supremacy clause is interpreted, and the U.S. Supreme Court declared that states cannot interfere in operation of the national government because the national government is superior to that of the states. The specific verbiage is the power to tax is the power to destroy. So can Maryland tax, regulate, or otherwise control an entity of the United States? And the obvious answer is no. Furthermore, the Supreme Court goes on to state that the power to create also implies the power to maintain. So if the national government has the power to create a national bank, then it also has the power to maintain it, regardless of what a particular state might wish. While the national government has delegated power, states have reserved power. It is impossible to come up with a list of reserved powers. That is because reserved powers are those powers that states have, and they are only limited by those things that are expressly forbidden to do. In essence, a state can engage in any action, do anything it wants, unless there is a rule against it, in that there's a specific prohibition or that the power has been delegated to the United States. Between the two, delegated and reserved powers, states have a much broader grant of authority than does the national government. The national government of the United States also has some power that we call inherent power. Inherent powers are those powers that all national governments get. If a government doesn't have inherent powers, it is not sovereign. An example of inherent power would be the ability to define boundaries. Nowhere in the Constitution of the United States does it give the national government the ability to define the boundaries of the United States. However, if the national government of the United States couldn't do it, then the national government wouldn't be sovereign. So there are a few things that the national government gets to do that aren't specifically delegated to it. These powers are called inherent powers. There is also a degree of overlap in power and authority between states and national government, and in the United States we call these concurrent powers. An example of a concurrent power is the ability to tax. Both the national government and state governments have the authority to tax. So this small area of overlap is called concurrent powers. There are some powers, however, that are denied. They are called denied or prohibited powers. In the original text of the Constitution, there are a few things the national government is expressly forbidden to do. These things can be referred to as denied or prohibited. So in many ways, the power of the United States government is limited two ways. Number one, it can only do those things that it has permission to do. And then furthermore, there are specific prohibitions against actions that it might take. Okay, so if we look at the delegated powers of the United States, we can break them down into about 5 broad categories. So while the Constitution lists out power of the national government and breaks them down into 17 clauses, it's a little easier if we categorize them. And again, we can categorize them into 5 broad categories. These categories would include, number 1, the power to make fiscal policy. Fiscal policy is the power to tax, spend, and by implication, borrow money. This is going to give rise to what is called fiscal federalism, and we'll talk about that in the federalism chapter. The national government of the United States has the ability to set monetary policy, which deals with the amount of money in circulation. The amount of money in circulation will be able to be manipulated as a way to try to affect its value. The national government has the power to regulate commerce, which is both interstate commerce and commerce outside, in between the United States and another country. The national government of the United States has the ability to set military policy, and finally, it can also set foreign policy. Pretty much every function of the national government can be broken down or can be categorized into one of these 5 categories. So if you're thinking about is a function of government national or state, if it fits into one of these 5 categories, it's probably national. If it doesn't fit into one of these 5 categories, it is probably state. And again, these powers are specifically mentioned in detail in Article 1, Section 8 of the Constitution. The Constitution of the United States is often referred to as an adaptable document. The reason why the Constitution is adaptable is because, number one, it is short. This can be held in contrast to many other national constitutions and in contrast to the constitutions in many states. Whenever you write something down in a constitution, you increase the probability that it will become obsolete. So simply put, if you don't say it, you don't have to change it. The Constitution of the United States could be rendered in about 12 typewritten pages, and it really doesn't say very much. There's very little policy in the national Constitution. Rather, the National Constitution of the United States is a policy-making framework. This can be contrasted with many other national constitutions and state constitutions that not only have policy-making frameworks, but also contain specific policies, which have to be amended with great regularity. The Constitution of the United States is also vague, which means it's up for interpretation. This gives rise to what is sometimes called informal amendment. The Constitution of the United States has phrases that say, for example, that the national government can regulate interstate commerce, but doesn't spell out in any great deal what would constitute interstate commerce. So the definition of this term has changed over time, and as such, it has caused the power of the national government to increase or decrease. So the Constitution can be amended informally by simply changing the way that we look at it or changing the way that we interpret a specific provision. The Constitution of the United States also provides for formal amendment. To have a formal amendment requires 2 things, a proposal and a ratification. Again, you cannot have a formal amendment without both a proposal and a ratification. There are 2 ways to propose and 2 ways to ratify. In essence, there are 4 ways to formally amend the Constitution. Proposing a formal amendment can take one of 2 forms. Number 1 would be 2/3 of both houses of Congress can propose an amendment and send it to the states for ratification. Another way to propose an amendment is a national convention. A national convention can be called by 2/3 of the states, and then it can propose amendments that would be sent to the states for ratification. I want to emphasize that states themselves cannot propose amendments. Rather, it is only Congress and a national convention. The ratification process, there are 2 options to ratify an amendment. Number 1 would be 3/4 of the state legislatures. 3/4 of the legislatures in each state can vote to approve the amendment. And then finally, you can have special ratifying conventions, and this allows you to bypass the government of the state. So if 3/4 of the states approve it, then the amendment is added to the Constitution. And there's 2 ways to determine whether the state amends it, and that's state legislature or a special ratifying convention. The most common method of proposing amendments to the U.S. Constitution is by proposal by 2/3 of both houses of Congress and approval by 3/4 of the state legislatures. All amendments to the United States Constitution have been proposed and ratified that way, except for the 21st Amendment, which was proposed by both houses of Congress and then ratified by special ratifying conventions. To date, the National Convention method has never been used as a means to propose an amendment.